All right, I'm going to try this again. When was the last time you had something to drink?
Something to drink this morning. Coffee.
Any alcohol.
Oh, that's fine.
Everyone's giving us that from here. State your name, please.
Manuel Ramirez.
Thank you.
We are here for a pretrial and there's also a bond violation.
Yes.
The reason being because he did not go to community corrections as ordered after his arraignment. I did speak with him about it and he stated that he was confused. He didn't realize he needed to go. He said that he was trying to pay attention to what Your Honor was saying. He was nervous. He heard the last thing that came out of your mouth, which was the next court date, and that's kind of all he remembered as his arraignment was finished. We did speak about the warrant. He did fill in the warrant recall. He did not put himself in because he's in school. He's at Washington Community College. But he is here. He does want to address the warrant today. He is willing to go test right now. And he believes he can come back clean. And he's asking for warrant to be recalled and another referral to be made to community corrections so he can get back.
Cancel the bench warrant that's out. I'll reinstate previous bond. Defendant to report before he leaves this facility to community corrections for placement on a SCRAM tether this time. So we don't have an issue. All right. And then I'll adjourn this out. How much time did you need?
I think the 18th should be okay, Your Honor.
I'll adjourn this to September 18th, 2024, 9 a.m. You understand that, sir?
Yes.
You need to get over to community correction. All right. Thank you.
Consider it G as alternate. Take the LHG is 2.206.
Sir, if I give you a test that's going to detect alcohol, whether or not you consumed alcohol recently, are you going to pass that test?
I'm pretty sure.
Why aren't you absolutely sure, Mr. Allen?
Because I don't drink alcohol.
What do you mean you don't drink alcohol?
Stay away from anything that's gonna get me in trouble. I'm just trying to fix everything, you know. I'm just trying to get back in order, you know.
When's the last time you drank?
Probably like 2 years ago. Hey, somewhere right there.
Well, that can't be true.
Probably like. Well, I just haven't been drinking, you know. I haven't drank anymore.
All right, I'm going to try this again. When was the last time you had something to drink?
Something to drink this morning. Coffee.
Any alcohol.
Oh, that's funny.
Okay, probably like 12 months ago, maybe. Somewhat. Can't remember, but you know, 12 months ago, let's say.
So you haven't consumed any alcohol for the last 12 months?
No. Probably mouthwash, you know. Something that.
Council approach. Okay, so here's what I'm going to do. Sir, I need straight answers to my questions. So I'm going to give counsel an opportunity to talk to you about how you address the court and answer the court's questions. So, Mr. Allen, if you could have him have a seat over here, and Ms. Parody will get to you as soon as possible, and we'll see where we go from here.
So remember, I did have a chance to speak to my client. We did speak about the answers to your questions and how it's important to give straight answers. I think he's quite nervous, and I think that impacts his demeanor here today. But again, I emphasize that the court wants straight answers. regarding his drinking, he does think that he's going to pass. He indicated he has not used any drugs, marijuana, or alcohol. He believes that the last time he drank was around the time of this offense, and hasn't used anything since.
Is that right?
Yes.
Just send him over. He's gonna be put on a SCRAM unit. I also want. You haven't used any drugs? ETG, and I want a urine test on you also. So when he goes over, I want a one-time drug test. And then if he's positive for anything, it's gonna continue weekly. And then also an ETG, and he's gonna be placed on a SCRAM tether.
Would you like him to come back after his test, or?
No,
Okay,
we'll catch up to him.
alright,
Thank you.
thank you.
Fine to continue at this time.
Thank you.
What we just watched is a textbook example of how courtroom credibility can unravel, not because of a major confession, but because of inconsistent answers under judicial scrutiny. This wasn't a dramatic outburst or a heated argument. Instead, it was something far more dangerous for a defendant: hesitation, confusion, and shifting timelines when the court demanded clarity. Let's start with the legal context. This hearing wasn't just a routine pre-trial, it also involved a bond violation. The defendant failed to report to community corrections after arraignment, which is not a minor oversight. When a judge releases someone on bond with conditions, those conditions are non-negotiable. Missing a reporting requirement can immediately trigger a bench warrant, which is exactly what happened here. The court did show flexibility by recalling that warrant, but flexibility does not mean leniency without verification. Now look at the judge's focus. The repeated questioning about alcohol wasn't random or aggressive. It was deliberate. Alcohol consumption appears tied to the underlying offense, which means sobriety is likely a condition of bond. That's why the judge keeps rephrasing the same question. When was the last time you drank? Courts do this intentionally. When answers shift from 2 years to 12 months to mouthwash, the issue becomes less about drinking and more about truthfulness. Here's the key legal takeaway. Judges don't expect perfect memory, but they do expect straight answers. Saying, "I don't drink alcohol," and later saying, "probably 12 months ago," creates a contradiction. Even nervousness doesn't erase that. In fact, the judge explicitly acknowledges the defendant's anxiety, but still insists on clarity. That's important, because nervous defendants are common, but unreliable statements are not excused by nerves alone. The defense attorney does what good counsel should do here: steps in, reframes, and clarifies. She explains that the defendant hasn't used alcohol or drugs since the time of the offense and believes he'll pass testing. That clarification likely prevented immediate detention, but notice what happens next. The court doesn't just take that reassurance at face value. Instead, the judge orders objective verification, edgy testing, urine screening, and placement on a SCRAM tether. This is where accountability becomes concrete. SCRAM monitoring is not symbolic, it's continuous alcohol detection. Edgy testing detects alcohol metabolites for days after consumption. Weekly testing, if positive, adds ongoing supervision. In short, the court is saying, if you're telling the truth, the data will prove it. If not, the consequences escalate quickly. Ask yourself this: if you were in that defendant's position, would you have handled those questions differently? Would clearer, more direct answers have avoided heightened supervision? Or was the court right to tighten control given the inconsistencies? From a broader perspective, this case highlights a critical lesson for anyone navigating the justice system. Compliance is cumulative. Missing community corrections, hesitating under questioning, and giving unclear answers don't exist in isolation. Together, they shape how a judge assesses risk, honesty, and reliability. In the end, the judge balances caution with opportunity. The warrant is recalled. The bond is reinstated. But the leash is shorter now. Monitoring replaces trust, because trust has to be earned back step by step, test by test. And that's what makes this case compelling. No shouting, no grandstanding. Just the quiet pressure of a courtroom where every answer matters and where the margin for error gets smaller with each pause. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.